What is the nature of correction, sir? Premises number is wrong. Very good. To be under the heading for correction tomorrow. Note it down.
My lord, may I please?
Give me a second. Yes, madam.
May I have your lordship indulgence, my lord? Item number 29 of today's case, madam.
Then wait. Yes.
For correction in the order. My lord.
Correction. Just what is the nature of correction?
Instead of Jagdishpur Gram Panchayat, it was written Haldia Municipality.
Hey, what I note for now? For correction tomorrow. Under the heading for correction tomorrow. দুটো হলো, ঠিক আছে? Yes, sir. It is.
Now, what is happening is the respondents are giving the opposition in free swing.
So, what do you want?
Okay, I want extension of my time to file affidavit like the opposition filed by the respondent.
When the matter is supposed to be listed?
Tomorrow. I just wanted to bring to your lordship notice so that I could not.
So mention at the time of call tomorrow.
I shall.
Very good. Yes, madam.
My lord, item number 29 of today's session. Instead of today, my lord, kindly keeps it on 22nd. My lord, Mr. S.N. Mukherjee will be leading me in this matter. My lord, based on his instruction.
Rosmi Metallics.
Yes, madam. My lord, I have spoken with Ms. Chandra Alap. She is for the other side. My lord, she doesn't have any. I am not asking for any fixation of time, just on 20.
আসুন তো এ আছেন এয়ারপোর্ট আছেন সে কি কোথায় You want which date?
22nd, madam.
নোট করে রাখো তো 22 তারিখে 22nd January.
His lordship, may I have you? May I permit to mention?
এটা হচ্ছে আইটেম নাম্বার 29 22 একে
His lordship, may I have your lordship's kind leave lordship to lordship mention the matter. Lordship, this matter lordship, his lordship WP number 11856 of 2010 lordship. The lordship has heard at length and on lordship 20th December 2024 and lordship has been pleased to fix the matter as CAV lordship.
As
CAV lordship. His lordship yes, lordship.
Judgment has not been passed.
No, lordship. The matter is CAV lordship. May I have your lordship's leave to lordship file this case law? Lordship, this is your lordship's judgment only. Lordship on the point that if the dismissal order is held to be valid, it lordship doesn't mean automatic back wages. Lordship, paragraph 24 of lordship's judgment. This is lordship's judgments only. Paragraph 24, lordship. Lordship, if the dismissal order is held to be valid, it doesn't mean lordship. Paragraph 24, lordship. Paragraph 24, lordship.
Give me a second.
Yes, lordship. Lordship, this matter was heard at length by lordships on 28th December 2024 and lordship marked it as CAV.
Sir,
yes, lordship.
it is a
lordship
judgment.
Yes, lordship, it's lordship's own judgment, lordship. This is your lordship's judgment. Oh, lordship. Paragraph 24, lordship, may I be allowed?
Why are you bringing to this notice?
No, lordship, on the last occasion, lordship, probably we couldn't submit the judgment. Lordship, so we are lordship giving this.
I cannot follow, sir.
Yes, lordship, on the last occasion when the matter was heard, lordship, we were to submit this judgment, lordship. Yes, lordship. So we are handing it up today, lordship. Because this lordship's own judgment where dismissal order is held to be valid. Lordship,
for my perusal.
Yes, lordship. Yes, it's lordship perusal, lordship.
Oh, I see.
Yes.
Thank you very much.
It doesn't mean automatic.
It has been reported, which is why it has been.
Yes, lordship.
Thank you very much.
Handling.
Thank you very much.
Lordship.
But may I permit to mention, my lord, one hearing matter of 2018, my lord.
Hand over the slip. Have you served notice? Very good. এই শোনো এগুলো যেগুলো মানে নোটিশ আছে সেগুলো সবই হিয়ারিং এ চলে আসবে অল দ্য লিস্ট কিন্তু আমার কোথায় এয়ারপোর্ট কোথায় My air code, I am handicapped, my air code, none of my air codes have come.
My lord, am I audible, lordship?
ছিল তোমরা?
My lord, in item number 1, lordship, I am appearing for the petitioner. My lord, this matter has been come under the heading to be mentioned, although, my lord, I have not mentioned this matter.
No, there was a typographical omission in the order, which is why it has been placed under the heading to be mentioned. Listen to
Lordship.
the instant matter is placed at the instance of the department. Since a typographical omission occurred in paragraph number 10 of the last order dated 6/8/2024. Stop. In view of such, in paragraph number, in view of such, in paragraph number 10 of the order dated 6/8/2024, in the second line, after the words, single inverted comma মধ্যে লেখো, learned judicial magistrate, comma, inverted comma close. The following be inserted. Single inverted comma মধ্যে colon দিয়ে, single inverted comma দিয়ে লেখো, first class. FIRST first class. হ্যাঁ, এই যে উপরে লেখা রয়েছে দেখতে পেয়ে যাবে, এখানে একটা মার্ক করে দিয়েছি, ফার্স্ট ক্লাস। স্টপ। The paragraph, the instant order may be treated as part of the order dated 6/8/2024.
I am grateful, lordship.
Item number 2, my lord. My lord, one restoration application.
Have you served, sir?
Yes, my lord.
What is the affidavit of service?
Affidavit of service. My lord, very simple, my lord. Restoration along with section 5, then not pressed.
Not press means?
Not pressed,
এই
repetition,
দাও গো affidavit of service কল্যাণ বাবু।
then repetition not pressed. And my lord,
Read petition was not pressed on which date?
my lord, I will today, for first time, restored, lordship, I am paying for restoration
Oh,
along with section 5.
thereafter you will pay for restoration.
Thereafter not pressed, I am paying for not pressed.
Oh, I
My
see,
lord,
I see, I see.
and only one line, the liberty to approach before the appropriate forum.
Very good. আচ্ছা লিখুন, আসুন ভাই, the
910 days delay,
Affidavit-
paragraph 5.
affidavit of service as filed today is taken on record. Can dispose of, WPA dispose of. Dismiss.
Well, this is my application, my writ petition, my lord.
My lord, I have been instructed by Mr. Mr. Tilak Bose is there, my lord, on behalf of the respondent, my lord, he's on the way. This special fixed matter, sir. Can we not,
They will fix it some other day, my lord, suppose.
should I keep it Passover?
Well, password, because I have a virus challenge which I'm going to oppose.
Very good. On behalf of the respondent.
And for the petitioner,
It is a contempt.
yes, content matter was taken up by your lordship on 18th of December.
Yes, sir.
And we, contempt of opposite parties has filed the appeal
Huh.
and was reserved to obtain stay order. But no stay order has been.
It is
obtained by-
submitted as auto. An appeal was preferred with the proper prayer for stay and copy of the following sir. In view of the pendency, let the matter be failed to bring any stay order on the adjourned date. Pass.
Lordship, Pradeep Kumar Das is the senior counsel, Lordship, in this matter. Lordship, I have not instructed anything about this. Only, Lordship, I am praying a short accommodation only for not this today, no, not today.
Very
actually.
good. Just I'm making it not today only. Not today. একটা line লিখে নিন on behalf of call the next matter.
This matter, I am appearing for the petitioner, my lord. And these are
As
contempt.
per the alleged contemner,
My lord, there is a
notice has been served.
no, my lord. This is the first time, my lord.
Give me a second.
There is a
Uh,
Tamrolipto municipality, my lord. And my lord, private respondents are there.
What is my order?
My lord, order, my lord, page 22, my lord. Page 22 of the contempt application, my lord. Well, the municipality has done nothing, my lord. No inspection, no reason order has been passed, my lord.
Representation has been considered.
No, my lord. Nothing has been done, my lord. My representation, my lord, page 19, my lord.
Who is the respondent number 3?
Respondent number 3, my lord. Board of Councillor, Tamrolipto municipality, my lord. My lord's order was, my lord, to cause prior inspection, prior to hearing and prior to passing the reason order. my lord.
No, you have to read from paragraph number 5, madam.
Yes, my lord.
This court, while disposing the respondent number 3. Who is the respondent number 3?
Respondent 3, my lord, Board of Councillor, my lord, of the Tamrolipto municipality, my lord.
Respondent number
Representation has not
3.
been considered.
Respondent number 3 is the board of councillor.
Yes, my lord.
And then what order has been passed? So representation was not considered.
No, my lord. Nothing has been done, my lord.
Let me see.
And
Liberty is
prior
given
to that, my lord,
cause inspection of the prior to chairman and the executive officer. Very good. Ashun. The repeat
my lord, I am appearing for the petitioner, my lord. My lord, in this matter, I am appearing for the Howrah Municipal Corporation led by Mr. Shondipan Banerjee. My lord, kindly see my lord's order, my lord.
This is the first
My
time.
lord,
Yes, my lord, first time.
my lord, a copy may be served
My
upon us.
Nothing has been done, my lord. My lord, only my lord. Whole has been done, my lord. Whole. Only small hole has been done by the corporation.
Where is my order?
My lord, order, my lord, page 18, my lord.
Page 18. Howrah Municipal Corporation.
My lord,
Lord, are
kindly see,
disposing
my
this
lord.
as per author to proceed with the provision of
Initially, my lord, 177 has
give
been.
me a second.
Yes, ma'am.
One 177 subsection 7 provides for causing demolition,
Yes, my lord. Self
self demolition.
Yes, my lord. My lord, private respondent has done nothing, my lord. Thereafter, my lord.
Approach the appropriate authority. No,
177.
please come to paragraph 5.
Yes, my lord.
এই আমাদের মিউনিসিপাল কর্পোরেশন গুলো আছে গো বইগুলো বার করো দেখি হাওড়া মিউনিসিপাল কর্পোরেশন অ্যাক্ট
Subsection 7. Such being the position, the court while disposing the instant writ petition permits the
হাওড়া মিউনিসিপাল কর্পোরেশন
respondent, Howrah Municipal Corporation to proceed with the provision of 177
জাস্ট মিনিট ওই তো দেখতে পাচ্ছি হাওড়াটা ওই যে নীল রঙের বইটা পরেরটা হ্যাঁ 177 now. When no appeal has been preferred against an order of the commissioner to municipal the commissioner may himself cause the
Yes.
building of the work
Yes, ma'am.
is to be so commissioner is to be commissioner shall who is the
My lord.
yes commissioner ashun
Only my lord, just whole has been done, my lord. Nothing has been done.
so the demolition is to be carried out
Yes, my lord.
acha person is not a party.
Yes, my yes, my lord.
The functionaries of the Howrah Municipal Corporations are the alleged contemptors. So I will not record your presence. You file your Fokalatnama. Have you filed the Fokalatnama on behalf of the alleged contemptor?
Mr. Shondipan Banerjee filed a vocalatnama.
Yes, filed.
Lordship.
He is the panel lawyer of Howrah Municipal Corporation, my lord.
Very good. I'm giving by What application is this?
On behalf of the petition of
Your Lordship, for the state, I'm led by Ms. Sonal Sinha, Your Lordship. Just receive
as per
the.
your lordship, as per your lordship.
Huh?
directive.
Thank you very much.
হ্যাঁ এই সেটাই তো
আর সব
হ্যাঁ ইনস্ট্রাকশন তো দরকার
কবে থেকে this is the restoration application. Only 15 days delay, मेरा. As per your lordship direction, I have always served with other. Though
They are opposite parties are represented.
yes, my lord.
I'm
He has
for the
appealed
state.
of the state, and actually,
Then upon whom you have served?
now
Director
for
of
the
food-
state has been to direct to sub other state respondent. Though he is appearing on behalf of the state respondent,
Give me a
but
second.
on the
Rotua সমবায় কৃষি উন্নয়ন সমিতি have you served?
no, he is petitioner, my lord.
Oh, I'm sorry. State of West Bengal,
On the
Director of Food and Supply,
he is appearing instead of he has
the District Controller and the, so all are the state and its functions. Very good. Ashun,
unnecessary.
I have not received the instruction, it was very old matter, you know, I need some more time to get the instruction.
You will
Will
file
release the
instruction
copy.
on affidavit or you will file affidavit opposition?
No, we will first receive the instruction, if your lordship thinks fit that it is required to be heard by exchanging affidavit, then we will file the
The
affidavit.
vacancy has been declared. We put the
2009 matter,
irrespective
your
of-
lordship,
Yes.
let us take
You
the-
have the copy of the writ petition?
Yes,
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 but I
yes.
have already searched.
Very good. Very good.
Long-
WPA. Call the next matter.
I appear for the response. But I appear for that. Give me that.
Have you served?
My lord, Mr. Prasad is appearing.
Yes, my lord, I
Mr. Prasad,
yes, my lord, I
you intend to file any affidavit opposition?
Dear my lord, this is review.
Yes.
My lord, in my most respectful submission, there were three days hearing, my lord, by on the part of my friend. Detailed argument was made.
Forget about that. Just tell me in support of the review against the you intend to place a oral argument or you intend to file the.
No, if your lordship will so inclined, Lord, I can.
No, I'm not. I'm not entering into the merit.
I can file, my lord, if your lordship so inclined, I'll have to file, my lord.
I'm not insisting, sir. It is you have to protect your client's interest.
My lord, then, my lord,
Lord, although not, it was my duty not to annex some documents along with the review application.
Huh.
But it transpired in course of proceedings that not there were other proceedings initiated by the Provident Fund authorities, not where employees were deprived of their dues. And Provident Fund authorities in such other proceeding before coordinate benches of this honorable court has agreed that they are owing certain amount to the bank. They have not transferred amount to the bank. No, this is coming from a Ministry of Finance order, Government of India, which directed that all employees of this regional rural bank should be covered under the pension scheme And
Oh,
therefore-
it is that 14B
Yes, yes.
matters.
And therefore, Provident Fund authorities should refund the amount which they are holding to the bank.
So what are the new facts you have
But
agitated?
three documents, please have a look not at the review application.
Milord, same advocate on record said everything, Milord, and if
Say
they are saying
that
we
can
are
be
not
done
aware of
by
first proceeding.
Not same advocate appeared before your lordship, who appeared before the
Yes, I have
coordinated
said
bench.
so. I have
He
said
ought to
so.
have brought this to the
I have
honorable
said
court's
so.
notice that he
Hey.
appeared in the matter wherein
Hey,
a certain amount is payable by the Provident Fund authorities.
No, lawyers. Lawyers may be same. Judge may be same. There is no
Fact
difference.
may be different.
Hey, accept. Question is, any specific case has been made out for taking the that's
Kindly consider
Kolan
whether
Babu.
these documents are needed.
Kolan Babu, it করবে এটা ফুল ফ্লেজেড হিয়ারিং হয়
Grateful to you.
In this matter, my lord, I am appearing on behalf of the petitioner along with my friend.
You are the answering respondent, sir. You are
I
the
have-
answering respondent.
I have some.
Give me a second. You have served, sir?
Yes, this is the evidence of service.
Take it to the. Mr. Siddiqui is appearing on behalf of the state.
State, yes.
And you are Mr. Samanto.
State led by Mr. T.M. Siddiqui, he engaged court number 11, your lordship.
Give me a second. You are for the state. You are for school. Just a minute. Just a minute, sir. What are the cans which are pending? So many cans are pending. Can 9631.
So their substitution, the original petition are typed.
Those are not. Those have been disposed of.
Yes,
Cans have been disposed of.
Can has already been disposed of. Now the writ petition to be heard out.
Then why cans are showing pending? When the cans have been disposed of, sir? On all occasions, it is order sheets are being typed as with can numbers. Can 17. 1747 disposed of. 1747 achi? No. 174. So for 9631 and 756 are concerned, what are those cans? 9631 and 756.
Mistake, Milord, in the application there is a mistake. That's why the Honorable Justice Sogoto Bhattacharya directed me to file an application. That application has been filed.
So those have to be disposed of, no?
Both have Sogoto Bhattacharya has been disposed of. An application
Sir, just tell me by which order, but rather by which date's order can 9631 of 2009 and can 756 of 2024 have been disposed of? Please indicate. I do not find any such order. Please, sir.
I think the three can, 3 and 4. That number were political disposed of. I think that the Honorable Justice Sogoto Bhattacharya. That will be line number 1747 of the particular disposed of. What are the date? 5th August 2020.
5th August?
5th August 2020. I think
5th August
2020.
That is 1747.
1747.
Huh. But what about can 9631 and 756?
961 and 756.
Not disposed of. Not disposed of.
No, that has been disposed of. 756 is Milord. The Honorable Justice Sogoto Bhattacharya directed me there is some mistake.
Sir, by which order it has been disposed of, that I intend to know.
Only one has been disposed of.
That I have noticed. That is 1747. But I intend to know about 9631 and 756. Colon bar karo. Ei duto can bar karo. Prior to disposal of the Writ petition, those applications are required to be disposed of, no? একটা হচ্ছে 9631 ওল্ড নাম্বার, একটা হচ্ছে ক্যান 756 অফ 2014। Those two applications have been filed by the writ petitioner.
Yes, yes. Yes.
লিখে দিন 9631 756 বাবা 2009 এর একটা অ্যাপ্লিকেশন। Nine 9631 of 2009 is a prayer for reconstruction of the case
Yes,
bearing.
yes, that is reconstruction. But the file was not traceable. That's why this application has been filed for reconstruction.
Reconstruction of a CO.
No, the writ petition.
Is the main writ petition. Now, that record has been traced out and.
So it has now become infructuous.
Yes.
That reconstruction.
So 9631 of 2009 has become infructuous.
Yes, infructuous.
এই আসুন আসুন আসুন। আচ্ছা লিখুন। Or giving a fair.
That is higher pending.
Just a minute, sir.
What is called, what construction full building as well.
Not full building, playground only.
My lord, the entire property has been acquired.
Sir, sir, wait for a second.
Wait, wait.
I'm sorry.
What is your prayer?
That proceeding challenge.
LAP case number 3/82 of 83.
Yes.
What is the nature of the proceeding?
And the proceeding for construction of playground of the school. That school. We have challenged the in this writ petition that section 4(1) of the Land Acquisition Act, 2 daily newspapers for the regional language publication must be made. It is mandatory. But here in this case, only one publication was there. That has been challenged in this writ petition. That's why and that petition was heard by coordinate bench of this court. That is Horidas Das as his lordship date was, and his lordship dismissed the petition, holding that one publication is sufficient. Challenging that order, my client preferred action, and the appellate court, after hearing both parties, that order was set aside, directing that.
How you are going to be affected with the land acquisition? You are the recorded owner.
Recorded owner, and very.
You have not received the compensation.
No, nothing.
Yes, that part. He is entitled to get compensation on because the entire property belongs as the acquired. Wrong because of that. Giving 30 years to his running. I can school. There are several students are allowed to go. They are paying the playground. Big playground is there. Not the school is the building. Thousand students are playing in study. Now, Lord, he is the only one plot number, substituted from someone and under the acquisition. The house will be able to take and the entire property has been acquired. He only entitled to get compensation. I am not.
My lord, I am
Mr.
sharing it.
Siddiqui is not ready today.
No, Lordship, he engaged court number 11, your Lordship.
So I'll give it Passover.
Passover, either Lordship, not today.
Your Lordship, ask for that.
Very good. He's speaking not today. I'm only adjourning this for this day only. আচ্ছা লিখুন এবার WP টা লিখুন at this stage on behalf of the respondent state an accommodation has been sought for on the personal ground of Mr. Siddiqui.
Tomorrow.
It's the adjourn only for this day only. আচ্ছা ওইটা না এই করলেন এইটাই কিন্তু যে call the next matter.
I am the petitioner, my lord, led by Mr. Kamolesh Bachchan, my lord.
You will do the case or you will prefer time?
My lord?
You will do the case or you are seeking?
Yes, I am ready to do this.
My lord, so far, my lord, I am appearing for the state respondent, my lord. My lord, under compelling circumstances, I am submitting, I have misplaced the brief. I also prepared the notes of argument. But since morning, my lord, I am searching, could not find out. 2 days accommodation. I want my 2 days accommodation, my lord.
My lord, as by your lordship direction, my lord, affidavit of service, my lord, I have served the opposite party, my lord.
Exchange of evidence are complete.
Completed, my lord.
But this is, my lord, this is for, since on the last occasion, we are not there, your lordship directed to serve us the copy. For that, my lord,
very good. But it is a matter of 1998. So exchange of evidence are complete.
Yes. Yes.
Complete, my lord, argument was going on.
On behalf of the respondent state, an accommodation has been sought for.
No, I thought the state respondent. He is going to
Well, state respondent, kindly.
So that I have recorded. Yes, on behalf of the respondent state, an accommodation has been paid for. Therefore, accommodation is considered allowed. How much time it require? 2 days?
2 days.
Accept so. We don't.
But some more time, my lord, so that I can, my lord, again, prepare, and I have to take the copy from him also.
Stop.
Not this week.
The matter is. Whatever, sir.
Oh, one thing, my lord, the previous matter, my lord, kindly fixed it tomorrow at 2 p.m.
No,
my lord,
sir.
So that, my lord, the learned.
No, sir, no, sir. I shall consider. In the event he is not available, I shall consider.
Grateful.
Morning. That's why
In hearing case.
Am I so bad?
No.
Am I so bad? Or the location of the court is so bad?
No. Everything is good.
We are very old age. About 71, 72.
I understand.
Because the Siddiqui is not available in the morning. So many.
Very good,
time,
very good. I shall
that's why
consider.
Kindly fix it so that he.
No,
can
I'll not
accept.
fixing to. I'm not fixing it today.
All right.
If Mr.
Come on.
Siddiqui is not available, I shall fix a time.
Okay, I'm due.
Call the next matter.
My lord,
I am appearing for the main answering respondent, that is the respondent number 3 and 4, West Bengal State Cooperative Bank Limited. My lord, although I am prepared with the affidavit in opposition to the 2 CAN applications, that is one condonation of delay for filing restoration application and for the restoration application, being CAN 206 of 2019 and 205 of 2019, my lord. From the record, it appears that the bank filed its affidavit in opposition to the writ petition of 1998 in the year 2000. But my lord, even after my repeated attempt, I couldn't found out the writ petition, the affidavit in opposition of my client of the year 2000.
Yes.
Otherwise, my lord, I am having the writ petitions of 1998 and the comprehensive writ petition that was filed later on by the petitioner, and also the applications. My lord, may I be allowed to file the affidavit in opposition to the 2 CAN applications? my lord?
Sure. Give it to us. As against the writ petition, have you received any? Who is for the petitioner?
My lord, I am for the petitioner led by Ms. Devjani Sengupta. My lord, I have not got the copy, my lord, for opposition.
My lord, they have filed affidavit in reply, my lord. I am having affidavit in reply with me.
Give me a second.
And my lord, these are the copies of the letters whereby
You have
the
received the replies?
Yes, my lord. I have
Replies
received
to the
reply.
replies to the
Reply
replies.
to these 2 affidavit in opposition, my lord. The reply was affirmed on 21st August 2019.
What is the reply?
My lord, this is the reply, my lord. Ms. Devjani Sengupta appearing in this matter, she is engaged in courtroom number 16, my lord. I am praying for only not today, my lord.
That is not a ground for adjournment, sir. देख नहीं आस हटो दाओ every in opposition. I'm sorry, 6625. What is that? এটা দেখতে পাচ্ছি না। হ্যাঁ এত পুরনো মামলা সব। সালে মামলা ডিসমিস হয়েছে, ডিসমিস হওয়ার পর সেটাকে এখন রেস্টোরেশন করতে চাইছে।
My lord, there was a delay of whopping delay of 3,749 days. My lord, I am relying upon a decision, reported decision of an honorable.
Forget
division
about
bench of our-
decision, just keep, let me accept your affidavit in opposition. It will get a
I have
But what is the
annexed
what is the other can? Have you got any idea? Can double six
My
two
lord, I
five
have- I have no instruction about the other can of year 1999.
আসুন লিখে নিন হচ্ছে on January 17th. So affidavit reply are to be filed in the meantime or করলেন এটা অ্যাপ্লিকেশন হেডে আসবে আচ্ছা এক সেকেন্ড এটা লিখে দিন তো ভাই
Lord, I beg to appear on behalf of the petitioner before your lordship. That this is a case of your 2000.
It has been mentioned at your instance,
My lord.
The case has been mentioned at your instance.
Yes.
Have you served notice? Yes, you have served notice.
I was told that notice was served upon the respondent. I was told by my clerk.
But there are three learned advocates, but only
I am
one
proceeding-
endorsement.
I am proceeding in respect of petitioner 1 and 2. Others are not contesting the matter.
Who are the respondent number 1 and 2, sir, madam?
No, petitioner number 1 and 2. Torun Kumar Kuit and Borun Kumar Kuit. Both of two was only 4 plots are involved in the petition.
Who are the answering respondents?
Answering respondent land acquisition collector and the Hulia Development Authority. They are the requiring body and state is the
Who are the requiring body? Hulia municipality.
my lord.
Who are the requiring body?
For Hulia municipality was there for construction.
Who are the requiring body?
Requiring body is Hulia Development Authority.
Hulia Development Authority.
And acquisition.
An acquisition has been done by respondent number 8.
My
Land acquisition collector.
my lord.
So have you served upon them?
Yes, notice. I have got the notice now. Learned advocates were notified on 1/10/2024. It was such a reason.
Mr. Hassan and Mr. Afrajul Haq.
And they happen to appear in the petition. Very short point is involved in this case, but you will find from the document that section 4 notification, section 6 notification for recommendation. Those notice says that after lapse of 2 years, award was granted under section 11, and no notice for accepting the award published by them, if any, under section 12(2) of the 1894 Act. I have already
Madam, in the year 2022,
my lord.
Mr. Hassan appeared on behalf of the municipality and Mr. Hawk appeared on behalf of the Haldia Development Authority. Are they still in panel?
I am told that they are in panel. I do not know. They have received, when they have received, my lord.
But they have not turned up.
My lord. That is fine. But I am still in possession. My name has been recorded in the
No.
LR record of right.
Very
I
good.
am paying the rate.
I'm not saying anything about merit.
My lord.
I intend to know whether they are still in panel or no. In the event they have been served on 30th September. No, you serve appraise.
Again, sir.
Serve. Ashun.
Then your lordship kindly
Fix a date.
And
Fix
time.
it. I'm fixing it.
Coming every time due to my own.
No.
Your lordship kindly fix and time. I shall certainly appear.
Very good. As per request made at the bar, let the matter be listed on January 22, 2025 under the same heading.
My lord, Mr. Partha was appearing for the petitioner in this matter, your lordship. Lordship, he is in another court, my lord. My lord, I am praying for not this week, your lordship.
Why not this week? Why not this week? Busy in court today at 12:04. So not this week.
Lordship, then short possible, your lordship.
It is better to make it go out of the list.
Lordship, I am praying for short possible, lordship.
Municipal Can 2 of 2014. এই ক্যান 2 of 2014 টা বার করুন তো ভাই। ওল্ড ক্যাম্প নাম্বার হচ্ছে 1183 of 2014। দেখুন ওটা স্টে কিনা। হ্যাঁ হ্যাঁ ও এটা 15 হচ্ছে, আমি সরি ক্যান 2 of 2021। হ্যাঁ হ্যাঁ ঠিক, সরি। Restored the writ petition by recalling, have you served?
My lord, it's already restored, your lordship.
তাহলে এটা দেখাচ্ছে কেন? ক্যান 2 dispose of, কি রে ভাই এরা unnecessarily এগুলো সব দেখিয়ে দেয়। ক্যান 1 ক্যান 2 সব ডিসপোজ অফ হয়ে গেছে। Exchange of evidence are complete. Where is Mr. Amol Kumar Sen and Mr. Jalodi Das? They are still in panel. Then where have you served?
Yes, your lordship.
Where is the notice? Exchange of evidence are complete. ওই এখানে তো এফিডেভিটের কোথায়? এখানে লেখা there is a recording of the in the earlier order.
My lord, Mr.
The
Jagadish Das.
pleadings are complete in the matter. Liberty is reserved to mention the matter for early hearing before a bench taking hearing matters. So where are the pleadings? কিছুই জানে না।
My lord, affidavits already exchanged, your lordship.
But those are not available in the file.
Opposition and reply already. It is ready for hearing, your lordship.
My lord, may I appear in online, my lord, in this matter, my lord, running my junior
Yes.
my lord.
You are appearing on behalf of?
Because the petitioner, my junior is there, my lord. Actually, I am in chamber, my lord. I am to.
Wait.
My lord, may I clarify the position, my lord?
Just a minute, sir. I will hear you. I shall pass. I undertake that I shall pass no order without hearing.
I know, my lord.
Yes, sir. Make your submission.
My lord, here, my lord, what happened? My lord, actually, my lord, if you lordship kindly fix at 2 p.m., my lord, I will come physically. But thing is, my lord, the Mathabhanga Market Regulatory Committee, my lord, had taken a certain amount from my client for allotting a, my lord, particular, my lord, plot. Particular, my lord, shop room.
Shop room.
I have paid the, my lord, amount, and my lord, still, my lord, they have completed, my lord. Initially, my lord, they said there was a no, my lord, construction is going on and construction has been stopped. And subsequently, my lord, it was, my lord, found that the constructions has already been completed and all allottees have been given the, my lord, their respective shop rooms except the petitioner. This is the short issue. I am to pay the balance amount and they will, my lord, allot the, my lord, shop room in the Mathabhanga Market Committee. This is the issue, my lord.
So you have issued a notice to them.
Yes, yes.
So let them consider the notice as a representation.
No, they have filed, my lord, affidavit in opposition. This is old
Nothing
matter.
is there. Nothing is there.
No, they have filed, my lord. They have filed. They have filed.
দেখো তো
Copy is
এবিডি
lying with us, my
কোথায়
lord.
বলছেন আছে when they have filed.
Well, it's an old matter, my lord, but they have filed, my lord.
Have you the copy of the affidavit in opposition?
Yes, yes, my lord. It's lying with the file.
Affirm on 15th June 2004.
Give it to me. Give it to me. What is the case? Why they are, according to them, what is the, why they are not using, allotting the room?
Well, kindly fix at 2 o'clock, my lord. I am coming, my lord.
Then intimate your other side. Mr. Jalodi Das, that will be taken up
My lord.
at today at 2 p.m.
My lord.
Today কে appear করেছেন? Mr. Amol Kumar Sen and Mr. Jalodi Das for state. But the Mathabhanga municipality is the answering respondent, no?
But they are not coming, my lord, since long.
Then they are required to be served.
But they have filed the opposition, my lord. I have, my lord, given to your lordship, my lord.
Every norm we have to do 3, 4.
Their stand will be clear from the opposition itself.
So who is appearing on behalf of Mr. Devasis Gun?
But Devasis Gun, they are not now not appearing, my lord. I have asked to them, my lord. They have, my lord, returned the brief.
Sorry. Very good. Come back at 2 p.m.
Lord, may I get back, my lord, the opposition? I will, my lord, have one with photocopy, my lord.
Yes, yes. এটা ফেরত দিয়ে দাও উকিল বাবুকে এটা ফেরত দিয়ে দাও এটা 2 p.m. এ প্রথম ম্যাটার ডাকা হবে Please inform your other side.
My lord.
And if possible to Mr. Gun, please ask Mr. Gun to that this court has requested to come to court at 2 p.m.
My lord.
Grateful, Lord.
এটা 2 p.m. থাকবে এইটা না 16.
My lord, 16, I am for the petitioner, your lordship. Long back, your lordship has directed to file opposition. But it is my fault, my lord. I am only seeking 7 days extension to file my
Why are you
application.
standing in the side of the petitioner?
My lord, I am for the petitioner.
So why you will file opposition?
My lord, reply, sorry. It's my mistake, your lordship. Affidavit in
16
reply.
with
Your
17.
16 with 17. 17 is the contempt application and 16 is my petition.
So it has been mentioned at your instance.
No, your lordship, it is running for long. Actually, the contempt petition was appearing, and thereafter we informed your lordship that we want to finish the writ petition of. That's why your lordship has fixed
In
the
terms of the honorable court, no affidavit in reply appears to have been filed by the concerned Ato. The Karadama has been filed by myself.
Actually, my lord, this is an old petition. Some documents were required to be That's why it took so long.
What's your name?
Promojit Mishra.
Promojit?
Mishra is the Lord. My lord, kindly takes up the last order, 17th September. Your lordship.
That I have seen.
Yes, your lordship. I am only seeking the period to file my affidavit in reply. Your lordship.
It was September.
Yes, your lordship. My mistake, it is a 2008 writ petition. They are, the
Who are
department
the
is
outside
unable to.
respondents?
Answering respondent are the private party.
এই রিট পিটিশনটা কোথায় গো? দেখি একবার রিট পিটিশনটা।
And my lord, one more thing, some of the respondents
You
have
have
died.
to read in the nature. So why the impugn order?
My lord, we have challenged the order passed by the Industrial Tribunal, your lordship.
Okay.
That was against
Industrial
us.
Tribunal.
Yes, your lordship.
What order has been passed?
They have directed for reinstatement of those employees who has been retrenched by the petitioner.
Oh, you are for Calcutta telephones.
Yes, your lordship. And
And
my
they
lord,
are,
as
they
far
are
as
for, they are for the workmen.
workmen. And during the contempt proceeding,
You are appearing on behalf of the private respondent.
Yes.
my lord,
Yes,
during the contempt proceeding, they had indicated that some of the respondents here have died, but I am unable to trace who are their legal heirs or nothing was communicated to me. If in the meantime that direction can be passed, then I can make the necessary corrections in the writ petition and as well as I can file my reply to the writ petition.
Some of your clients have died.
Yes, ma'am.
Some of the private respondents have died.
Yes.
So they have to take steps then.
If they communicate us, we will take the necessary, make the necessary corrections.
So please communicate. Ashu.
And my lord, the time to extend.
Similar, I brought the state respondents, my lord.
Lordship, on behalf of the petitioner also, I am praying short pass over learned advocate, Mr. Anil Jana is appearing at courtroom number 11, Lordship. And get
Pass
him
over.
pass.
Similar, carry my lord at 2 p.m. my lord. Another matter is.
2 p.m. I have fixed one matter.
Then thereafter, my lord. kindly.
Then 2:30.
2 p.m. we have two matters.
My matter, if your lordship permit me, third matter, my matter will be lord. If your lordship kindly, my lord.
Then I'm making it not today.
Not yet. Okay.
3 p.m. Lordship.
3 p.m. I'm supposed to from the criminal matters. 16, 17, 18, not today.
Yes.
My lord, I am for the respondent and it is my executing the position.
This is my reply.
Okay, reply please. My lord, reply is being served here and right now.
Yes.
I'll have to go through it. Attending.
Come tomorrow.
Yes.
But day after tomorrow.
Day after tomorrow. The Philippine opposition. Tomorrow, sir.
At the time of hearing, my lord, I will point it out.
Well, 20, Mr. Govinda Boyda appearing on behalf of the petition.
It is either on 19 or 20.
20.
আগেটা কত ছিল? Yes, sir.
Well, I did item 20, well, I'm praying, well, not today, well, on behalf of.
Just a minute, just a minute. হ্যাঁ। করেছে? এটা কি ডিপার্টমেন্টে গেছিল? তারপরে কি হলো? Yes, sir.
Well, in this matter, Mr. Govinda Boyda appearing on behalf of the petitioner.
Hmm.
My lord, he is on legs, my lord, before my lord justice, my lord, Sina, my lord, code number 13, my lord, I'm my lord, praying not today, my lord.
I will serve, have Mr. Boydo served upon the land advocate for the respondent 1 to 4.
Service করেছো? Yes, my lord.
Ashun, on behalf of the read petition and accommodation has been paid for. Prayer for $21, who is appearing? 2010 সালের মামলা। Mr. সায়ন্তন কর। The petitioner is not represented today?
Milord, item 22 and 24, I will be led by Mr. Piyush Chaturvedi. And number 23 is led by Mr. Sudeep Shanal. Both are senior counsel, both are busy in other courts. My humble submission before this honorable court is to fix a particular date and time so that everybody could come here and do the matter.
Ma'am, what will happen that every lawyer seeks similar facility?
My lord, I am for
Then-
the state.
That's why
I am for the state.
it's for your consideration and at your convenience,
No.
Milord.
Simply not today.
Long pending case.
I'm appearing for the petition, Your Lordship.
Earlier occasion, my lord, on 17th September 2024, your lordship was pleased to pass me the order and giving me the opportunity to file an amendment application, lordship. We have filed, and your lordship also directed to serve upon all the respondents. We have served, my lord. This is the service. Affidavit of service. My lord, the West Bengal Corporation.
Give me a second.
I apologize.
দেখি দাও করলেন Is the amended application?
Lordship, amendment application, and my lord, I have filed my affidavit of service also, lordship, before your lordship.
It is the affidavit of amendment application that you have filed in the department. Twice.
Your lordship has given me the opportunity to file before the 3rd December, my lord. But my lord, we have not able to do this, lordship, the file before your lordship on maybe it's 12th December, my lord. Instead of 3rd, my lord, it was filed before your lordship on 5th December, my lord, in the department.
In the department?
Department, my lord.
filed in department on 5th December, my lord.
কোথায় অ্যামেন্ডেড কপিটা কোথায়? It is by a supplementary affidavit.
No, my lord, this is a CAN 4, my lord. This is a CAN 4 of 2024, my lord. Arising out of WP number 1675W of 2010. Application, my lord, amendment application.
তো ক্যান 4 তো দেখতে পাচ্ছি না, কোথাও রয়েছে রে বাবা? এটা আইটেম নাম্বার 25।
My lord.
ক্যান 4 কোথায়? এটা দেখুন, আমি দেখতে পাচ্ছি না কোথায় রেখেছেন। Can 1, 3, those have been disposed of?
My lord, CAN 1, my lord, it was a restoration application. It was disposed of by your lordship.
ক্যান 4 তো এখানে দেখাচ্ছি, ক্যান 4 of 2024।
My lord, also we have filed an affidavit of service, my lord. May body appear. Our answering authority is Cooperative Society, my lord.
Very good. Let can 4 be traced out whether it is available in the file or not. হ্যাঁ, দেখুন আমাদের কাছে পাঠিয়ে দিয়েছে কিনা। না না, আমাদের লুজ পড়ে আছে কিনা এরকম হতে পারে না। এখানে লিস্টে শো করছে, তার মানে তো নিশ্চয়ই পাঠাবে। What is scam 6669 of 2013 that has been disposed of?
No, my lord, both the can, there is, my lord, 110750 and 6669. Therefore, filing for wages and arrears, my lord. That is I am praying before your lordship, the all total together I have to file an amendment application, which I have been filed before your lordship, and that is before your lordship for adjudication, my lord. Because that time I'm in the service lordship, and here now lordship I am attending my age of superannuation.
So 111710, you have prayed for setting aside then quashing of the order of suspension.
Suspension, my lord.
So both the applications have become infructuous now.
My lord, not infructuous because the
But these
department
applications can be disposed along with the main writ petition.
main writ petition, my lord. Because departmental inquiry
ওটা পাওয়া গেল ক্যান কোডটা?
and the criminal proceedings are two different procedure.
তাহলে এটা এটা এইগুলো কোন রেজিস্টার দেখে গো? Let a copy of
Number 26, I am appearing on behalf of the petitioner. Your Lordship, I am led by Mr. Vishal Majumdar. My Lord, due to some difficulty, my Lord, he has come to the court, Your Lordship. So I am, Lordship, I am praying that maybe he may be kept on witness, Your Lordship, will not be available today.
I appear for the state, Your Lordship. Let it be recorded that he is seeking for
Yes, yes.
time.
As per request made on behalf of the
Item 27, my lord, I appear for the petitioner. My lord, due to some difficulty, I am praying that the matter be kept in the next week so that the
as per
affidavit.
request made on behalf of the petitioner, the matter is learned advocate for the writ petitioner is hereby request.
I am for the writ petitioner, my lord.
Mr. Mukherjee, because of the long absence of the court in the single bench, probably the lawyers have lost interest or they have
Not the lost interest, but now
No, I was in circuit.
circuit, then with Justice Bhattacharya.
That is which is happening.
They were supposed to file a report. I think that was the last order.
Lalit Mohan Mahata.
Whether the matter pertains to compassionate appointment in a panchayat department. Now,
Where is Mr. Mahata?
now the matter has been filed in 2012, and the petitioner is active. There are 3 times the recommendations have been made. 3-member committees formed. They recommended that this gentleman fulfills all the criteria for granting the appointment. Still, it was not done. Now, I also have to find out whether the petitioner really now.
নিয়ে নিন আর কি করা যাবে
Lordship 30, I am appearing for the opposite party railways, Lordship.
None appears on behalf of the writ petitioner, though none advocate for the respondent / railway authority is represented. In view of such, let the matter be listed on January 16, 2025 under the heading for dismissal. All,
So I can 31, I'm paying for only one day accommodation, Your Lordship.
not today. Who is for 32?
Lordship, I'm praying for time. Lordship, my senior.
Not today. The parties are not represented. Let the matter be listed on. Appear করছেন? Item number 33, anybody appearing?
My lord, I am appearing on behalf of the state, my lord.
For dismissal.
Anybody for the petitioner?
January 16th.
লিখুন, the petitioner is not represented, though full stop. An advocate for the state is however present in virtual mode. In view of the absence of the writ petitioner, let the matter be listed on January 16, 2025 under the heading for dismissal.
Much obliged, my lord.
Give your slip, give your appearance.
Give your appearance.
(34) who is appearing?
I was appearing, my lord, in item 30. I could not make myself appear before Lordship, my lord, because of some technical problem.
Item number?
30, my lord.
30 তে কি অর্ডার হয়েছে গো? ওগুলো আছেন রেসপন্ডেন্ট স্টেটের?
Railway, it was not the railway.
Anyway, no adverse order is passed today. Ensure your appearance, otherwise it will be dismissed. Because your other side is not present.
Your Lordship has fixed any other date, my lord?
Dateটা বলে দাও। January 16 under the heading for dismissal, you appear, I shall take up the hearing.
That's right, my lord. Thank you. Oblige your Lordship, my lord.
(34) who is appearing? কেউ ভার্চুয়াল মোডে আছেন?
Yes, my lord. I am for the state. Yeah, I am for the state, my lord. In this matter, led by Mr. T.M. Siddiqui, my lord.
এই 34 তো অর্ডার হলো নাকি? ওই same order, same date under the heading for dismissal. Supply your name.
Much obliged, my lord. Okay, my lord. Answer.
Next.
At 35, Mr. Ekramul Bari appearing on behalf of the petitioner. He is on legs, my lord, bring not today.
Or not today.
My lord,
I am appearing for on behalf of KMD along with Mr.
My lord, I am appearing for the petitioner led by Senior Advocate Vikas Chandra Martin, who is appearing before Honorable Supreme Court of India. Kindly fixed, my lord, after 21st of this month, my lord.
On behalf of the petitioner, an accommodation has been paid for. I'm not passing any adverse order, but from tomorrow the situation will be otherwise. So be rest assured.
Lordship.
37 কেউ আছেন? Anybody is there in virtual mode? Gaurav, same order, same date under the heading for dismissal. Parties are not represented, huh? Next, 38.
My lord, I am for the petitioner led by Ms. Debjani Sengupta. My learned senior couldn't come today.
How much time you require? Only today, not today?
Not today, your
Very good.
lordship.
Item number 38, not today.
Obliged.
I am for the petitioner, my lord.
Who is your other side?
My
State?
State representative for previous occasion, my lord, they took time, my lord, to take instruction from the district inspector of schools, my lord, the matter relates to, my lord, payment of a retirement benefit, my lord, due to some dispute regarding overdrawal, my lord.
What is your prayer, sir?
My lord, prayer, my lord, two-fold prayer, my lord, there is a in tune, my lord.
এরা ভাই যদি লুজ সব দিয়ে দেন কিভাবে কাজ চলবে? হ্যাঁ, এটা সেলাই করতেই কত
না 39 ডেটটা কি হবে? ডেটটা কবে শুনি মানে 16 তারিখ
What is the illegality in the order?
My lord, there is a dispute, my lord, whether, my lord, my.
That has been duly resolved.
Yes, yes, my lord. My lord, now the issue, my lord, whether, my lord, I have, it was the, my lord, fault on the part of the respondent school. My lord,
why?
My lord, my lord, they have failed to, my lord, produce the leave application of the petitioner, my lord, so, my lord, even, my lord.
No. There is a clear finding of fact that you have not submitted the leave application.
My lord, that's why, my lord, last occasion I was, my lord, prayed before, my lord, they let there be direction for filing a opposition, my lord, in respect of my lord,
Why?
application.
If it is apparent on the face of the record.
But if, my lord, no, my lord, if, my lord, there are some documents, my lord, if they controvert, my lord, then.
You show that you have filed the leave application?
That apart, my lord, the issue of overdrawal, my lord, has been settled, my lord, by the Honorable Apex Court.
That has been duly dealt with?
No, my lord.
It cannot be claimed as a matter of right.
If, my lord, the petitioner, my lord, enjoyed my lord, the amount which has been, my lord, paid in excess to his, my lord, salary, my lord, that was enjoyed, my lord, more than 5 years, my lord, before his retirement. My lord, that cannot be recovered, my lord. This is the, my lord, now the settled position of law. My lord, may I rely, my lord, the judgment of the.
Absolutely perfect order.
The judgment was reported in 2015 4 SCC 334. Kindly have a look. These have been
কি আছে দেখি?
Paragraph 18 has been, my lord, specifically stated, but paragraph 18, when can, my lord, recovery can be, my lord, can be made, and, my lord, when cannot be made, my lord. The paragraph 7.2, my lord, paragraph 19, my lord, is the entire judgment. My lord, the ultimate paragraph is, my lord, paragraph 18. My lord, the relying on this judgment, the in identical case, the one coordinated bench granted relief to the may I hand over the judgment. আসুন।
My lord, I'm sorry, my lord. I'm asked from pool number 10, my lord. 34 item, my lord. It was most probably, my lord.
No, adverse order has been passed, I believe. কি order হয়েছে?
Fixed it, my lord. Any day, my lord, fixed it, my lord.
Come on 16 January, I suppose.
My
It will appear on 16 January under the heading for dismissal. In the event you ensure your appearance of the other side, it can be taken up on that. Serve notice that it will be listed on 16th.
My lord.
I'm for the petitioner.
Your reply is filed?
Yes. In this matter, what happened, my lord?
Give me a second. What is the order of dismissal?
Order of dismissal. Page 23, annexure P2.
Yes, Mr. Shah.
Yes. On 26th August 2001, the petitioner was allegedly labeled a charge of taking some materials out of the factory by the security personnel of the Durgapur Chemicals Limited. Thereafter, 28th August 2001.
Just a minute. Let me note the date. Yes, what is the date?
26th August 2001, allegation of theft against the
26,
petitioner.
26, 10.
No, August 8.
26, 9, 2001.
26, 8, 2001. 8.
26,
8.
26 August
2001.
Yes.
Labeled an allegation of theft against the petitioner while he was in duty.
Yes.
On the same date, FIR was lodged against the petitioner.
Yes.
Under section 379 and 411 of the Indian Penal Code.
Yes.
And criminal case registered being Kokoban Police Station case number 116/2001.
Yes.
Within 2 days from the date of initiation of the criminal case, suspension order was issued against the petitioner. That
is 28th August.
Yes.
28th August 2001, suspension order issued.
Yes. Then, my lord, on 5th September 2001,
suspension order issued in contemplation of a departmental proceeding.
Departmental proceeding.
Very good. Next.
5th September 2001.
5th September 2001.
issued a charge sheet against the petitioner.
Charge sheet issued. Yes.
That is all the same allegation of theft. On 2nd November 2001, the inquiry officer issued a letter to the petitioner intimating that the inquiry will be held on 20th November 2001. 2nd November 2001.
So initiation of disciplinary proceeding.
Initiation immediately after issuance of charge sheet, and 2nd November 2001, inquiry officer issued a letter.
Inquiry officer
issued a letter fixing date of inquiry on 20th November 2001.
What would be the next date?
20th/11/2001.
20/11/2001. Yes.
On 19th/11, the petitioner made a representation to the inquiry officer after obtaining bail in connection with the criminal case on 14th September 2001.
Yes.
That was not considered. Thereafter, on 16th June 2014, your petitioner was acquitted from the criminal case.
Date?
16th June 2014.
16 June 2014.
14.
13 years after.
After 13 years, criminal case ultimately ended with acquittal by the learned judicial magistrate. Thereafter, the petitioner made another representation on 19th August 2015 after obtaining certified copy of the order. They kindly allow me to join my duty as I have been acquitted from the criminal case.
Yes, Mr. Shah.
Then 7 December 2015, the petitioner sent a legal notice to the respondents by stating entire facts. That has not been considered. That had not been considered. Thereafter, the petitioner moved an application before this honorable court, that is on 15th February 2017, to cancel the dismissal order, which was ultimately passed on 15th February 2017.
15th February, first writ petition filed.
First writ petition, 2017.
Prayer?
For setting aside the order of dismissal, which was passed on 12th February 2002, as the petitioner had been acquitted from the criminal case. Because self-same facts and identical witness, the proceedings was initiated, disciplinary proceedings.
For setting aside the order of dismissal?
Yes.
So what order has been passed there?
That order at page 50.
Page 50?
50. Start from page 53. Page 50 is the cause title. May I read, Milo?
For consideration.
Yes. Thereafter
for
the-
consideration of your representation.
of my representation.
Give me a second. Yes. Then what happened?
Then passed an impugned order, my lord. Prior to going to the impugned order, my lord, trying to see the petitioner's representation. That is at page 36.
Petitioner's representation prior to filing of the first deed petition.
Yes, ma'am. After
Yes.
acquittal of criminal case.
Yes. That is on 19/9.
That is on 19th August 2015.
No, you said, Mr. Shah, on 16th June, 16/6/2014, acquittal order was passed.
Thereafter made representation.
On 19/9/2014, another representation made by the writ petitioner praying to allow him joint duty.
19th August 2015.
19th August
2015.
Very good. And thereafter you issued,
I have filed a writ petition.
no, issued a legal notice
Legal
at
notice.
7th December
Yes.
2015.
7th December 2015. Absolutely correct.
So where is the representation at 19/8?
That is page 37.
Page 37. Please.
I beg to draw your kind attention that I have been appointed as Group D staff of the Durgapur Chemicals Limited. That on 26th August 2001, the staff of the Durgapur Chemicals Limited lodged a FIR against me under section 379 and 411 of the Indian Penal Code before the officer in charge, Kokoban Police Station. And on the same day, the assistant manager personnel, by following the said complaint, suspended me from service and thereafter dismissed me from service. It is pertinent to mention here that on the basis of FIR, the concerned police station started a case against me under section 379 and 411 of the Indian Penal Code, filed GR case number so and so. On 16 June 2014, the learned Judicial Magistrate, Third Court, Durgapur, was pleased to deliver judgment in the following manner. The prosecution case in brief is that on 26th August 2001 at about 5:05 p.m. during routine checking of D-shift employees of Durgapur Chemicals Limited, the security guards of main gate, namely Nirmal Kumar Ghosh and Narugopal Ghosh, caught red-handed the accused person who was carrying on a plastic bottle containing a mercury stolen from the said chemical plant. You are kindly mark it. The security guards, namely of main gate, namely Nirmal Kumar Ghosh and Narugopal Ghosh, caught red-handed the petitioner. According to the complaint, who was carrying on a plastic bottle containing mercury stolen from the said chemical plant.
Yes.
I had ordered dated 14 December 2007, the content of charge for committing offence punishable under section 379 and 411 of the Indian Penal Code. So I read over and explained the accused person in Bengali, to which he pleaded not guilty as saying coming ignorant and claimed to be tried. Hence this trial. The accused person is examined under section 313 of the Criminal Procedural Code. In his reply, he pleaded his innocence. Points for consideration: whether the accused person is guilty of the offence, whether the prosecution side has been able to prove the case beyond all reasonable doubts. Both the points linked with each other are taken up together for the sake of brevity and conveying. The prosecution side has examined all the two witnesses. The PW1 happens to be the complainant of this case. The PW1, it is very vital. In his evidence has stated that he lost the instant complaint. The PW1 has further stated that on 26 August 2001 at about 5 p.m. the incident took place, and at that time he was security officer of Durgapur Chemical. The PW1 has further stated that security guard at main gate informed him. Security guard and men get informed him that one person with a plastic bottle has been apprehended during search. Who is the security guard? The security guard is the men get named Nirmal Kumar Guha and Narugopal Ghosh, who informed the complainant. But the security guard did not make any complaint. After the PW1 has further said he went to gate and found that one bottle meant for shampoo of 200 ml has been kept at the table, and he found the bottle too much heavy, and for that reason he informed the MD AK Upadhyay over telephone. The PW1 has further stated that MD came here and told that the content should be mercury, and MD called lab persons and lab persons confirmed that the content is mercury. The PW1 has further stated that the security guard Narugopal Ghosh and Nirmal Kumar Ghosh apprehended the accused Shashtipada Mondol. The PW1 in his cross-examination has disclosed that nothing happened in his presence. With his complaint, lodged complaint, the incident did not took place in his presence.
It may so happen.
But who is the vital witnesses? Nirmal Kumar Ghosh and
Let
Narugopal
us see,
Ghosh.
let us see.
Yes.
Whether it's a benefit of doubt or is an honorable acquittal, that is to be seen.
The further disclosed that nothing happened in his presence and he had not seen the accused with his material.
Yes.
The PW1 was further disclosed that there was a guard at that place from where the theft of mercury took place. The PW1 has further disclosed that on that day there was no complaint of theft. On that date there was no complaint of theft. The PW1 has further disclosed that one result list was prepared at gate, but he cannot remember who prepared it. The PW1 has further disclosed that he cannot remember whether he delivered that result list to police. The PW1 has again disclosed that after that police never met him on his incident. The PW1 has further disclosed that seized articles is not present in court. The written complaint is marked as Exhibit 1. The PW1 has again disclosed that he seized the article and handed over the same to police. The signature of the PW1 on the seizure list has marked Exhibit 2. The PW2 in his evidence has stated nothing regarding the alleged incident. There is no other evidence adduced by the prosecutor.
PW2 in his evidence has said nothing regarding allegations. So,
regarding the alleged
the
incident.
person who had apprehended the accused person, they have not been tendered into the witness box.
No. That is the
So that is the last line. The security guard named Narugopal and Nirmal was not examined by the prosecution side.
Neither prosecution side, not
the IO of the
not in the departmental proceedings. I shall show Miller. There is no other evidence adduced by the prosecution side. The PW1 is not in the eyewitness of this case. The security guard, namely Narugopal Ghosh, have not been examined by the prosecution side. The investigation officer of this case has not been examined by the prosecution side. The seized alamat has not been produced before the court. No independent witness has been examined by the prosecution side. As such, the prosecution case creates doubt about the fate of the incident. As such, in the circumstances and the evidence so far adduced, it is being pertinent that the prosecution side has not been able to prove this case beyond all reasonable doubt. Therefore, in the above circumstances, I am of the view that the accused person is not guilty of the offence under section so and so, and he is liable to be acquitted from this case.
Yes.
Hence, it is ordered that the accused person, namely Shashtipada Mondol, is found not guilty of the offence under section, and he is acquitted from the same under section 2481 of the Criminal Procedure Code. Therefore, 30th June 2015, I have made an application to you by stating an entire fact and requested to allow me to join my duty. That on receipt of my representation, you have directed me to furnish a copy of the order of acquittal. In compliance with your direction, now I am enclosing the Xerox copy of the order of acquittal. In view of above, I therefore request you to kindly do the needful so that I can join my duty and maintain my life and life. This is my representation. Thereafter, already I have placed the order of this court. And then, my lord, kindly come to the impugned order. That is page 57. starts from page 58.
Yes.
Consideration of representation of the letter dated so-and-so in terms of the direction of the Honorable Justice. That is the facts mentioned in now. Fact. One C. Shottipada Mondal was charged with a charge sheet on 5th September 2001, as he had been caught red-handed at about 5:10 p.m. while going out through the main gate with some quantity of mercury, approx 2 kiloliters, bringing to the company. He, in his letter dated 26 2001, also admitted the said fact. He was simultaneously placed under suspension with effect from 27th August 2001, pending inquiry proceeding. During the period of suspension, who has paid subsistence allowance as per the rules. The material portion of the said charge sheet dated 5th September 2000 is quoted below. That on 26th August 2001, while you were passing out the main gate of Durgapur Chemicals on completion of general shift at about 5:10 p.m. on being searched by security personnel on duty at the gate, you are found to be carrying out some quantity of mercury, approx 2 kilograms, belonging to this company. The mercury was carried out in a plastic bottle around your waist by a jute rope. This was accepted by you in your letter dated 26 August 2001. The acts as above alleged to have been committed by you amount to misconduct under clause 21B of 14 of the standing order for workmen of the company and warrant your dismissal from the company's service. You are therefore required to explain within 3 days of receipt thereof when you should not be dismissed from the company's service. Should you fail to submit your explanation as required, it will be presumed that you have no explanation to offer and the matter will be disposed without further reference to it. Since the charges leveled against you are grave and serious in nature, you are hereby suspended pending inquiry with effect from 27 August 2001 as communicated to you by our letter dated so and so. During the period of your suspension, you shall not enter the factory of the administrative building of the company and cannot leave the station without proper written permission of the competent authority. During the period of your suspension, you will be entitled to get subsistence allowance as per rule. He did not reply to the said charge sheet denying the allegation. However, further to our charge sheet file number issued to him and not submitted any explanation to the above reference name. The management has decided to hold an inquiry into the charge leveled against him. The inquiry authority has submitted its finding on 7/12/2001 and same was forwarded to Sri Mondal by our letter dated 20th December 2001. I find from the records of the inquiry proceeding that full opportunity were given to Sri Mondal for conducting defense at the inquiry by examining his witnesses and cross-examining the company's witnesses, and that he was present in the inquiry proceeding. During the inquiry, although he was given an opportunity to be represented through a co-employee and to produce witnesses in his defense, he did not avail of the same. He had fully participated in the inquiry process. The records revealed that the disciplinary authority had carefully gone through the records of the inquiry, the connected papers and documents and findings of the inquiry officer, and concur with the findings and evidence recorded in the inquiry. The disciplinary authority was fully convinced that the charge leveled against Mr. Mondal as per standing order 21B of 12 had been proved and as such he has found guilty. I have considered the inquiry proceedings which clearly show that he neither raised any protest nor he put any objection before the inquiry officer during the course of proceedings of the inquiry as he stated in his letter dated 7/1/2002. Ultimately, by a letter dated 12/2, he was dismissed from the service of the company with immediate effect. The dismissal letter shows that the disciplinary authority have gone through the past records and found that no exonerating circumstances. Considering the gravity of the misconduct, the disciplinary authority dismissed him from the service of the company. On 19 August 2015, Sri Shaktipada Mondal wrote a letter to the management annexing certified copy of the order dated passed by the learned Judicial Magistrate, Third Court, Durgapur, hired by the learned.
So your dismissal order was passed prior to the passing of the order of the acquittal.
Hastily passed allegation of theft, complaint, 26, 28 suspension, and 12 February dismissal order when the petitioner was in case.
At that medial time, the petitioner was in correctional home.
Was in jail at that point of time in connection with the criminal case. He has participated in the inquiry proceedings.
Then?
No, reply. He did not file reply because he was in jail at that time.
But after he had participated.
Yes, yes.
At that medial time, he sought no liberty to file his reply or something like that. Very good. Let us come.
Compliance of the Honorable Court's direction. That is just page 63. This is the facts of the case. No.
Yes, sir.
By a letter number DCL, so dated Athos, the Mondal was requested by the undersigned to meet him on 31st March 2017 at the works of Durgapur Chemicals Limited, Durgapur at 11 AM, along with 11 documents. On 31st March 2017, Sri Mondal called on the undersigned and made following submission. Since I am not earning and therefore practically I am penniless, so kindly see if I can get the job. At present, I am working as daily paid labor here and there. My family is in very bad shape. My only son has to stop education due to poor financial condition. My son is also suffering from ulcer-related disease, and I have no money to arrange proper medical treatment for my job. I again request you to get my job. In the said representation, both of us have put our respective signatures. Sri Mondal was explained in recording in Bengali language, and being understood the recording is to be correct, put his signature without raising any objection. Consideration of the representation. In terms of the Honorable Court direction, the undersigned has carefully gone through the letter dated of Sri Mondal as well as the submission made by him on 31st March 2017. During the course of personal hearing afforded to him, the sum and substance of the said letter dated that he has supplied the real certified copy of the order dated 14 June 2014 of the Judicial Magistrate, Third Court, and requested the management to join his duty. In fact, by a letter dated as 24 June 2015, he made the same request to the management, and management by a letter dated advised him to supply the certified copy of the said order. I have carefully gone through the order dated 16th June 2014, passed by the learned Judicial Magistrate, Third Court, Durgapur, and also have gone through the records pertaining to disciplinary action taken against him. It is true that he has been acquitted after a period of 13 years from the criminal proceedings initiated against him. The reason for acquittal, as I have seen from the said order, are basically PW1 has disclosed that seized article is not in the court. PW2 did not say anything about the incident of theft. IO has not been examined by the prosecution side. No independent, that is very vital. No independent witness has been examined by the prosecution side. Considering all these aspects, the learned court was of the view that the prosecution case created doubt about the fate of the incident. The learned court was of the view that the prosecution could not able to prove the case beyond all reasonable doubt on the basis of evidence proper evidence. On the other hand, as would appear from the charge sheet dated issued by the management of the company, clearly indicates that on 26 August 2001, Sri Shaktipada Mondal admitted the fact of carrying out some quantity of mercury, approximately 2 kg, belonging to the company in a plastic bottle. He was carrying the plastic bottle full of mercury around his waist by a jute rope. Secondly, he did not submit any reply to the said charge sheet because he was in jail at that point of time. Secondly, he did not submit any reply to the said charge sheet denying the fact. Thirdly, the inquiry officer, on a consideration of the materials on record, had come to the findings to the following effect. From the evidence and materials on record, I find that on 26 August 2001, while Sri Shaktipada Mondal, Tomik, T number so and so, Sale House, CC plant, DCL was passing out the main gate of Durgapur Chemicals Limited on completion of his generalship duty on being served by security personnel on duty was found to be carrying out some quantity of mercury of about 2 kg belonging to the component contained in a plastic bottle tied around his waist by a jute rope. Accordingly, the above act committed by him to misconduct under clause 21B 12 of the standing orders for workmen of the company, I thus find that the charges brought against the Shaktipada Mandal have been established and proved beyond doubt. I have considered the standing orders of the factory where there is no provision of automatic reinstatement on acquittal by criminal court. In the instant matter, apparently it can be said that basic charge regarding allegation of theft may be the same, but that is same facts in between disciplinary proceedings and criminal case. May be the same, but the standard of proof regarding the domestic inquiry and the criminal trial are different. That is their observation. In a criminal trial, the charge is to be proved to the hilt or exclusive, whereas in case of domestic inquiry, it is based on preponderance of probability. Therefore, according to me, one cannot be mixed up with other. But here, not only facts is same and also the witness also same. Kindly note down. In the instant matter, one proceedings has been initiated keeping in mind the discipline of the organization, and another one has been initiated by the state on the basis of theory of crime against the society. As such, the standard of proof are also different. It may be the fact that after 13 years, he has been acquitted from the criminal proceeding, and that may be of various reasons, including absence of proper evidence. It is very much reasonable that an allegation may not be proved, as even the investigation officer of the case has not been examined as a witness to prove the case. Whereas in case of domestic, even hearsay evidence are admissible. It is not that in each and every case the allegation has to be proved beyond reasonable doubt. On the
Mr.
basis,
Saha, admittedly, after passing the order of the dismissal, you have not challenged.
I have challenged.
After passing of the order of the dismissal, have you challenged?
No. At that time, I was in jail. Yes.
Try to understand my question. On 26/8/2001, allegation was leveled for commission of an alleged theft.
Yes.
Simultaneously, two proceedings were initiated. One is criminal proceeding, another is departmental proceeding. Departmental proceeding came to be concluded before conclusion of the
criminal proceeding.
Now, I am asking you whether prior to passing an order of acquittal, you have cannot challenge the correctness of the order of the dismissal. Now, after passing of the order of acquittal, you approach the writ court by filing a writ petition. Where in the first round of litigation, the direction was for consideration. The only question I intend to put, how a judgment of acquittal had an overriding effect over an order of dismissal, which was passed earlier and which remains unchallenged.
Not challenged after that.
Had it been such a case that acquittal order was passed, and thereafter order of dismissal has been passed, and those are based on same facts and identical type of evidence were evidence in both the cases, I could have appreciated.
That is the case. In this case, that is the case, because the same facts and same witness.
Maybe, but they operate in a separate domain, sir.
Separate domain, but in case of same facts and same witness,
naturally,
in two cases, that is disciplinary.
Same set of allegation raises same set of allegation raises a question of departmental proceeding by submission of charge sheet. Another followed by an FIR, initiation of a criminal
proceeding.
So departmental proceeding come to an end, holding that you are guilty and you have been dismissed from service. You did nothing. You approach the writ court after acquittal order was passed. So how at this stage the writ court can intervene? That I
Because-
intend to know.
Because the facts is same facts, same witness. In case of same facts and same witness, the criminal case and disciplinary proceedings is going on, or passed an order in the disciplinary proceedings, that order is not sustainable in the eye of law.
In the
Prior to that,
in the criminal trial, the PW1 and PW2 have been examined.
and also PW1 and PW2 have been examined in the disciplinary proceedings.
And no other witness.
No other witness. That is the case. That is the case. And also, he has mentioned that you have admitted that you have confessed that yes, you have taken mercury. Admission is there, but during the course of inquiry proceedings,
So
I have stated.
the rules of evidence is very clear. The facts admitted need not be proved.
I am coming, my lord. I have stated in course of disciplinary proceedings in my examination that the situation compelled me to admit that has not been cross-examined.
Very good, but you did not challenge that order prior to the order of acquittal.
No, because this is the fact, and then they will argue that a criminal case is pending. Criminal case is pending until and unless criminal case is ended.
Very good. Make your submission.
Then we'll at page 69. Therefore, I am unable to accept the request of Sri Mondal for reinstatement in our organization. This is my consideration with response, and that is the rescind order. Thereafter, I have filed this writ petition, and this writ petition directed to file affidavit. And my lord, now kindly come to discipline proceeding. Starts from inquiry proceeding. Starts from page 32.
You are referring?
First copy of the complaint. Page 32.
Of the writ petition?
No, of the opposition.
May I submit only one thing, that you can approval. I'm not disturbing my legal friend. The thing is, if you Lordship kindly take the trouble to consider the past order passed in this matter, 14/6/2000.
No, sir, you will get your opportunities.
Maintainability of the writ application is under challenge. That's why I'm indicating that, nothing else. If the maintainability of the writ application is under challenge, my learned friend is to meet that same first.
Very good.
Without going into the
let's place this one. I shall consider. Yes, Mr. Saha.
That is complaint lodged by Nepal Chandra Nayak.
Page number?
Page number 32 of the opposition. May I read you? While I was on duty on B shift as a security officer on 26/7/2000 in the factory's main gate office, our security guard posted at main gate Sri N.K. Guho, Nirmal Kumar Guho and Sri Narugopal Ghosh. During routine checking to the employees under D shift of the time.
Not necessary. So this is the complaint.
That is the two persons are posting at the main gate, Nirmal Kumar Guho and Narugopal Ghosh. Who, according to them, who got red-handed the petitioner.
Yes. Page number 33 is your alleged admission.
Alleged admission. Page number 33.
Page number 3, alleged admission.
Yes. Then, my lord, proceedings of inquiry. That is, we come to page 40. This is the findings of the inquiry officer, how he has appointed, etc. Now, that
page number?
Page number 40. 40.
Proceedings of inquiry.
Kindly come to page 43, deposition of the witness.
Page number?
43.
Yes.
This is very vital. What is your name? Sri Nepal Chandra Nayak.
Hmm.
Who is the complainant of the criminal case?
Naturally. The de facto complaint.
Yes. Where you work and your designation. Security Department, DCL as Sub-Inspector Security. What was your duty on 26th August 2001? I was on B shift duty from 13 hours to 20.
Mr. Saha, I'm once again requesting you to highlight that after conclusion of the disciplinary proceeding, after passing of the order of dismissal, you have not challenged that.
Yes, that's true.
That's true. Question that has come before this court consideration, where an order of acquittal has been passed by the Judicial Magistrate Court, you have approached the filing by writ court. And we are now in the second round of litigation.
Yes, ma'am.
The only question that is to be considered, I believe, as to how a judgment of acquittal as passed by a Judicial Magistrate Court can set aside or can be overlooked. How a judgment of acquittal as passed by a Judicial Magistrate Court had an overriding effect over the judgment, over the passing, over the finding of the disciplinary authority. That is to be looked into only. Because you, at this point, I cannot allow you to question the correctness of the departmental proceeding. Because you have not challenged that. That has been set at rest.
I have challenged after acquittal of criminal case.
So that is you want to take benefit of the acquittal in the departmental proceeding.
Why I have challenged?
So where is the law to that?
Yes, I am coming. Why I have challenged that? Because of the fact that self-same facts, self-same witness. In case of different witness, I have nothing to say. I have nothing to say. M. Paul Antony is very clear. Self-same facts, and identical witness. In case criminal proceedings and disciplinary proceedings is going on, that will not be sustainable.
Very
good. And that's why I am.
Any other point, you, Mr. Saha?
Only this point involved.
Do you want to rely upon anything?
Yes, my lord. And now, my lord, that is, my lord put a question that after admission, what remains? That is at page 49, the deposition of the petitioner.
Mr. Saha, I'm not an appellate authority. I'm in a seat of judicial review. Yes, Mr. Saha.
Only I have left factory after outpunch in my car. Then I was called back to security office. In the security office was thrust by C. Nayak, Guho and Ghosh. That I was taking out some material out of the factory. They also physically assaulted me. To avoid the assault, I was compelled to give a written statement that the mercury was recovered from me. The management, with a motive to employ someone of the company's choice in my place, this case was got up by management to remove me from service. I did not agree with the statement. The management witness adopted again, but I request inquiry officer to find out facts so that I will get justice. I conclude my deposition. This has not been cross-examined. This has not been cross-examined. Therefore, the admission is not. Now, my lord, I am coming to that whether it is permissible or not. In case of violation of rules,
yes,
I am placing one judgment, that is 2011, 1 CLJ.
2011, Volume 1,
Calcutta,
CLJ,
Calcutta.
Bracket Cal, page
57.
2001.
2011.
Oh, I'm sorry. Give me a second. 2011, Volume 1,
Volume 1,
Calcutta Law Journal, within bracket Cal
page
57. Very good.
First title, State of West Bengal and others, Vidyasagar versus Vidyasagar Pandey and another. I am reading the head note and then listening the chart. Criminal.
Sir, don't go to head note. Show me the relevant paragraph, sir.
Para 14 and 15.
Para 14 and 15.
May I read, my lord?
Give me a second.
There, 66.
Yes.
The contradictory evidence adduced by the PWD before the criminal court should have been appreciated by the disciplinary authority while passing the final order.
So how it will come to the effect?
Yes.
The contradictory evidence adduced by the PWs before the criminal court should have been appreciated by the disciplinary while passing the final order. It means criminal order has been passed earlier, disciplinary order has been passed in a different.
That's true, but my representative should be considered on that aspect because this is the ratio of
Most less, unfortunately, the disciplinary did not discuss the finding of the learned magistrate and held the
constable.
Sir, it is not helpful to you. It is exactly opposite. Exactly opposite, Mr. Shah.
Before passing after passing criminal order, disciplinary dismissal order was passed.
Since both the criminal appeal and department initiated against the respondent are based on identical
charge
arising out of the findings of the learned magistrate in respect of the same charge.
Must prevail.
So there is no occasion because prior to passing of the order of the acquittal by a magistrate court, disciplinary authority passed the order of dismissal and you did not challenge that order.
Because at that time criminal case is pending.
So it is,
at
it is not applicable to you.
Then, my lord, I am.
It's not no way helpful to you, Mr. Shah.
M. Paul Anthony, my lord.
Mr. Shah, as of now, you don't have any very good case, sir.
Case is good, but because I have not come within time. Within
No,
time,
no,
why
no
I have
good case, sir.
why I have not come within time? Because dismissal order was passed earlier hastily, and thereafter, after long date, criminal case.
You know the basic principles for intervention in a judicial review.
I am placing Captain M. Paul Anthony versus Bharat Gold Mines Limited and another. This is the last paragraph. I did not.
Just a minute. Yes.
There is yet another reason for discarding the whole of the case of the respondent, as pointed out earlier. In criminal case, as also the department proceedings were based on identical sets of facts, namely the raid conducted at the appellant's residence and recovery
Mr.
of
Shah, you are reading which portion, sir?
last paragraph. That is at page 11.
Page 11. All right. There is
yet another.
Yes. I got it. Kindly read, kindly please.
There is yet another reason for discarding the whole of the case of the respondent. As pointed out earlier, the criminal case as also the departmental proceedings were based on identical state of fact, namely the raid conducted at the appellant's residence and recovery of implementing articles therefrom. The finding recorded by the inquiry officer, a copy of which has been placed before us, indicate the charge against the appellant were thought to be proved by the police officers and armed witness who had raided the house of the appellant and had effected recovery. They were the only witnesses examined by the inquiry officer. And the inquiry officer, relying upon their statements, come to the conclusion that the charge were established against the appellant. The same witness were examined in the criminal case. But the court, on consideration of the entire evidence, came to the conclusion that no search was conducted, nor was any recovery made from the residence of the appellant. The whole case of the prosecution was thrown out, and the appellant was acquitted. In this situation, therefore, where the appellant is acquitted by a judicial pronouncement with the finding that the raid and recovery or at the residence of the appellant were not proved, it would be unjust, unfair, and rather oppressive to allow the findings recorded in the ex parte departmental proceedings. In the ex parte departmental proceedings to stand. Here, departmental order was passed. Since the facts and evidence in both the proceedings, namely the departmental proceedings and the criminal cases, are the same, without there being any iota of difference, the distinction which is usually drawn as between the departmental proceedings and the criminal case on the basis of approach and burden of proof would not be applicable in that to the instant case. Of the reasons stated above, that it is allowed. The impugned judgment passed by the division bench of the High Court is set aside, and that of the learned single judge insofar as it purports to allow the restriction is upheld. The learned single judge has also given liberty to the respondent to initiate fresh discipline proceedings in the particular circumstance of the case, especially having regard to the fact that the appellant is undergoing this agony since 1985, despite having been acquitted by criminal court in 1987. So, here 1985 order of dismissal was passed and acquitted in the year 1987. We would not direct any fresh departmental inquiry to be initiated against him on the same state of facts. The appellant shall be reinstated forthwith on the post of security officer and shall also be paid entire areas of salary together with all allowances from the date of suspension till his reinstatement within 3 months. The appellant would also be entitled to his cost, which is quantified to 15,000.
Anything more?
Apart from that, as per standing orders, I am entitled to challenge the same after passing order of criminal case. That is 21 C, the standing order, 21 C2.
Standing order?
21 clause 21 C2. 21 within bracket C clause 2.
What does it say?
Relevant page is 20, my lord.
20 of?
Of that standing order.
Oh.
But kindly exclude me for mark. Okay.
একটুখানি পড়ে নিন।
দাঁড়ান আরেকটা আছে। আমি একটু পড়ে নিই। May I read, my lord?
Yes, sir.
If prior to that, my lord, kindly start from 21 C. Procedure for dealing with cases of misconduct.
Yes.
And relevant portion is page 20. May I read, my lord?
Please.
If on the conclusion of inquiry or as the case may be of the criminal proceedings, that means it
Yes,
should be
I got it.
Yes. The workman has been found not guilty of the charge. He shall be deemed to have been on duty during the period of suspension and shall be entitled to the same wages as he would have received if he had not been suspended after deduction of the subsistence allowance paid to him for such period. Upon the conclusion of inquiry or the criminal proceedings, criminal cases, as the case may be of the criminal proceedings. The payment of shall, however, be subject to workman concerned not taking any employment during the period of his suspension. So, after acquittal of in a criminal proceeding, I am entitled to challenge the same. What is the bar? Where is the bar?
Very good.
That is, yes, sir. That is also violation of the standing orders.
That's all?
Yes, my lord. I am not.
Very good. Yes.
Produce the other judgment because.
Thank you very much.
You kindly take the trouble of going through the order of 2018, where the maintainability of the rectification is under challenge.
Page number 18.
14/6/2018.
Order passed
Order.
at the initial stage in this petition.
14/6/2018. इसको kept open.
So, admittedly, my learned friend has lastly relied on the standing orders.
Yes.
Standing order is applicable. Standing order is framed under the Industrial Employment Standing Orders Act 1946, which is applicable to the workmen working in the factory. And I bow down to your lordship's observation that my
No, that is a prima facie observation.
No, that's right. I am trying to develop on that. That after termination or dismissal or the disciplinary proceeding, he waited till the criminal acquittal in the criminal case. He had got the right to challenge the order of dismissal. That is covered under Industrial Disputes Act 1947. And there are a number of judgments. I will just show 2 judgments of this honorable court, where it has been held that in case of workman, my learned friend's client is a workman, the relief under Industrial Disputes Act is available to him under section 2 capital A of the Industrial Disputes Act, as well as under that act he has got the right to challenge the validity of the domestic inquiry. It is started from 1963 Ludbul Singh's case till today. The same theory is there. The workman has got the right to challenge the validity of domestic inquiry, whatever he has to say. Now, if it is held to be valid, then under section 11A, the quantum of punishment should
Does
be.
it take away the right of the petitioner of his constitutional right to challenge under Article 226 of the Constitution of India?
Alternative right is there. On alternative ground that this Calcutta High Court has said he should go.
No, availability of an alternative remedy is definitely a part to a constitutional remedy.
Then
but if it is found that is fundamental right or constitutional right is affected.
Yes, my letter of client has not shown a single point of exception. 3 exceptions are there. Violation of natural justice, fundamental right, and his right to life is.
But the
nothing has been.
But the
there.
so far as the facts involved in the Paul Anthony is concerned.
Paul Anthony doesn't apply so far as this case is concerned because it is a workman. That's why I'm trying to take your honor, lordship, to the point. So far as workman is concerned, he is covered under Industrial Disputes Act. Lordship, kindly take the trouble to consider this. And under this act, when he has got an efficacious remedy, that has to be taken into consideration. Lordship, kindly take the trouble to consider section 2 capital A. That's why at the very initial stage, maintainability of the writ application was kept open. Judgment, brother.
You are referring?
Section 2 capital A.
The industrial dispute.
Where any employer discharges, dismisses or retrenches or otherwise terminates the services of an individual, any dispute or difference between that workman and his employer connected with or arising out of such discharge, dismissal and retrenchment or termination of shall be deemed to be an industrial dispute, notwithstanding that other workman or nor any union of workmen is a party to the said dispute. So individual he can raise it. Lordship, kindly take the trouble to 1999 judgment of this honorable division bench. 1999 SCC online, Calcutta, 433. This judgment was authored by Honorable Justice late Totrabhuta Sinha. Lordship, kindly take the trouble to consider para 25. Keeping in view the aforesaid decision, all Supreme Court judgments have been discussed, then keeping in view the aforesaid decisions, it must be held that where the petitioner is a workman within the meaning of the Industrial Disputes Act and order impugned is one relating to dismissal or discharge of the the appropriate remedy is not by invoking this jurisdiction of this court under Article 226 of the Constitution of India, but under Section 2 capital A of the Industrial Disputes Act 1947. Lordship, kindly take the trouble to consider what is the definition of workman, Section 2 small s. Too small s. Workman means, has the lordship got? Too small s. Definition clause. Just last clause.
Just
small s.
Two S.
Workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, and supervisory work. I am not coming to this supervisory and all these things. My learned friend's client was a showman. So his work comes within the purview of either manual or unskilled or skilled. So he is a workman. Now, Lordship, thereafter, though it is a single judge judgment of a honorable single bench, I tempted to refer this matter, this judgment, because of the fact language is very lucid and the reiteration of the earlier thing. 2001, 4 LLN. 1057.
Paragraph
10. In the instant case, the grievance of the petitioner, has your lordship got? The grievance of the petitioner is against the order of against an order of dismissal. Admittedly, the petitioner is a workman. The dispute is an industrial dispute within the meaning of an industrial dispute Act 1947. The petitioner thus has efficacious alternative remedy under the provisions of the Industrial Disputes Act before the forum created under that act. So why it is there? Because of the fact he has got the right to challenge the validity of inquiry. What my learned friend's client has said, that he was coerced to give the
Mr. De,
lordship.
I'm sorry for the interruption. Probably Mr. Saha is not logged with on these points.
Then if it is not,
if I have correctly understood, that it is admitted position that Mr. Saha's client has not challenged the order of dismissal, even submission of the charge sheet in an appropriate proceeding time or in an appropriate proceeding. What I have understood from Mr. Saha's argument, that a valuable right has accrued in favor of his client on acquittal of on account of an order of acquittal passed by a criminal trial, passed by a criminal court,
after 13 years,
passed by a criminal court on the basis of a self-same allegation and on appreciation of self-same set of evidence adduced by self-same witness.
No, that is not the fact.
I believe it is the core contention of Mr. Saha.
It is not the fact. Now, Lordship, I will.
No, please proceed with your own way. I don't want to disturb you.
If it is not
so far as maintainability point is concerned, you have stated that the appropriate relief is under section 2A.
Under Industrial Disputes Act.
And under the Industrial Dispute Act, which we will get from section 2A, because the petitioner is a workman under section 2S, within the meaning of 2S. Yes, come to the next point.
Now, if admittedly he is a workman, then his initial approach to the Honorable Court has been deprecated by this Honorable Court in a single bench as well as by a Honorable Division bench, considering all earlier judgments.
Sorry, I cannot follow.
He cannot come, a workman, when he wants to establish his right under standing orders, under model standing order or standing orders, certified standing orders, he has to approach the forum created under Industrial Disputes Act. And so far as 2001 judgment is concerned, your lordship will find a number of judgments are referred here. That's why, in spite of the division bench judgment, I have placed before your lordship the judgment of 2001. Lordship, kindly take the trouble 2001, para 11. The guiding judgment was Rajasthan Road Transport Corporation versus Krishnakant. para 11, Lordship. I have 10 I have shown before your Lordship. Kindly take the trouble to para 11. And in para 8, all other earlier judgments have been discussed. Para 11, I am troubling your Lordship. In Rajasthan State Road Transport Corporation versus Krishnakant, reported in such and such, the Supreme Court laid down various guidelines when the workman should be relegated to raise the dispute before the appropriate court. It is relevant to mention that two tests are laid down in this decision, para 35. Let's take the trouble. Next page. Similarly, where the disputes involve recognition, observance, or enforcement of rights and obligations created under the enactment like Industrial Employment Standing Orders Act. My learned friend, lastly, placed before your Lordship the certified standing order. Certified standing order is formed under Industrial Employment Standing Orders Act 1947. Lordship, kindly take the trouble to consider the Durgapur Chemical Certified Standing Order. Lordship, the first one, applicability and the scope. The company, has your Lordship got it?
Yes, yes.
The company and the workman engage in the company's establishment at Durgapur in the district of Bardhaman will be subject to the provisions of these orders, which will come into force in the manner indicated in section 7 of the Industrial Employment Standing Orders Act 1946. So my Lennox client wants to enforce the right.
Mr. Prasad, somebody is arguing.
Is trying to enforce the right which is accrued according to him under the Industrial Employment Standing Orders Act 1946. Now Supreme Court has said, similarly, when the dispute involves the recognition, observation, or enforcement of rights and obligations created under the enactments like Industrial Employment Standing Orders Act 1946, which can be court-assisted enactment to the Industrial Disputes Act, and which do not provide a forum for resolution of such dispute, the only remedy shall be approached to the forums created under the Industrial Disputes Act, provided they constitute industrial disputes within the meaning of section 2K. Now section 2K, if you will kindly take the trouble to consider section 2K, any dispute difference between the workman and workman, the employer and the workman, and the employer and the workman in connection with their terms of employment and conditions of service. Section 2K, Lordship, kindly take the trouble. Has the Lordship got it? Industrial disputes means any dispute or difference between the employers and the employers, or between the employers and the workmen. Industrial dispute is a collective dispute. By enacting section 2 capital A, this provision has been diluted that in case of discharge, dismissal, termination of service, and so far as Bengal is concerned, refusal of employment, an individual can come, a workman can come, irrespective of the fact his cause has been raised by other workmen concerned in the dispute or union. So this is a dispute covered under section 2 capital 2K, read with section 2 capital A. If that be the situation, Honorable Supreme Court is absolutely clear, it cannot be. And my defense client was a snowing. So obviously either he was unskilled.
So on account of the availability of an alternative dispute, alternative
efficacious
remedy as provided under the Industrial Dispute Act,
writ is not maintainable.
In view of the provisions of section 2 capital A, read with section 2 small s and 2K of the writ is not maintainable.
This is first limb of my submission, Lordship.
Very good.
And in the affidavit in opposition, I have raised this point.
Thank you.
It is not for at the bar.
I understand, sir.
Now, the second point before your Lordship, so far as in the domestic inquiry, what your lordship was kind enough to hear. Domestic inquiry and criminal proceedings. Now the question comes into play whether acquittal in criminal proceedings will automatically entail my defendant to claim for reinstatement. It is not, because the standard of proof are different. In case of criminal proceedings, the standard of proof, your lordship has seen here, conclusively it has not been proved. So the charge is required to be proved to the hilt, because it is a charge against the society. And so far as domestic inquiry is concerned, it is a disciplinary proceedings where the standard of proof is preponderance of probabilities. Lordship, kindly take the trouble to consider the judgment. (2015) 3 SCC 101. Para 11. It is interesting.
Give me.
May I please?
Yes, sir.
It is interesting. Has the lordship got it?
Yes, sir.
May I please?
Please.
It is interesting to note that the learned single judge went to the extent of observing that the concept of preponderance of probabilities is alien to the domestic inquiry. On the contrary, it is well known that the standard of proof that must be employed in the domestic inquiries is in the facts of the case of preponderance of probabilities. The Union of India versus Sardar Bahadur, this is a very famous case, Union of India versus Sardar Bahadur. This court held that a disciplinary proceedings is not a criminal trial. Thus, the standard of proof required is that of preponderance of probabilities and not the proof of beyond reasonable doubt. This view was upheld by this court in SBI versus Ramesh Dhingra, the Dinkar Pandey, more recently SBI versus Narendra Kumar Pandey. This court observed that the disciplinary authority is expected to prove the charges leveled against the bank officer on the preponderance of probabilities and not on the proof of reasonable doubt, which is the standard of proof. Now, lordship, kindly take the trouble. 2018.
2018.
1 SCC.
1 SCC.
285.
Para
20 onwards. Para 20, if you let you kindly take the trouble.
20
onwards. 20 to 23. Let you kindly take the trouble.
Just a minute. Yes.
Similarly, has the lordship got? Similarly, in our considered view, the Labour Court failed to see that the criminal proceedings and departmental proceedings are two separate proceedings in law. One is initiated by the state against the delinquent employee in criminal court, and other is departmental inquiry, which is initiated by the employer under the labor of established laws or the rules against the delinquent employees. The Labour Court should have seen that the dismissal order of the respondents was not based on criminal court's judgment. Lordship, kindly pausing for a moment, which your Lordship was kind enough to put to my learned offense time and again. The sequence is this: dismissal order has been passed 13 years prior to the order of acquittal. Can it be charged on this ground that my dismissal order is bad because after 13 years the acquittal was there? An acquittal, I will take your Lordship to the acquittal. It is not based on the same evidence.
Yes.
Then the very next line, what your Lordship was observing. It was, however, based on domestic inquiry, which the employer had every right to conduct independently of the criminal case. This thing your Lordship was repeatedly put to my learned offense. This court has consistently held in a case where the inquiry has been held independently of the criminal proceedings, acquittal in the criminal court is of no avail. That's why I have submitted before your Lordship, impol Antony does not apply. It is held that even if a person stood acquitted by the criminal court, domestic inquiry can still be held. The reason being that the standard of proof required in a domestic inquiry and that in a criminal case are altogether different. In a criminal case, the standard of proof required is beyond reasonable doubt, while in a domestic inquiry, it is the preponderance of probabilities. Then para 23, Lords. In the light of this settled position, the Labour Court was not right in holding that the departmental inquiry that the departmental inquiry should have been stayed by the appellant, awaiting the decision of the criminal court, and that it is rendered illegal consequent upon passing of the acquittal order by the criminal court. This finding of the Labour Court is therefore also not legally sustainable. The question which your Lordship was kind enough to put me, the answer is here. And that's why I respectfully submitted before your Lordship that impol Antony does not apply here. Facts are different. And here, the employer has got his right to proceed with the departmental proceeding independently than that of the criminal proceedings. So I do not know what criminal proceedings will hold. And it is not a case that because of the criminal proceedings he was dismissed. No, it's not. It is not that. I independently initiated disciplinary proceedings by, I will take your Lordship to the facts thereafter. Lordship, kindly consider the next judgment, 2014.
Just a minute. Give me a second. Next.
Now, Lordship, kindly consider 2014. 3 HCC 610. He speaks about certain provisions in the police regulation. That regulation is absent so far as I am concerned. Para 18, Lordship, kindly take that up. We indicate May I please your lordship?
Just a minute. Since it is already 3:34 and I'm supposed to take criminal matters after 3 p.m. So except this, no, don't stop. No other read matters will be taken up. If time permits, criminal matters will be taken up. Mr. De, please continue.
We indicate that the respondent could not. Lordship, may I please?
Yes.
Could
If time permits, definitely criminal matters will be taken up. Rest is up to you. Mr. De, please proceed. Sorry. Try your luck on the next day. Yes, Mr. De, please proceed.
we indicate that the respondent could not lay his hand on any rule or regulation applicable to the police force, stating that once an employee has been acquitted by a criminal court as a matter of right, Lordship kindly consider the word, as a matter of right, he should be reinstated in service despite all the disciplinary.
Mr. De, will you please kindly read?
Lordship, may.
Sorry.
We indicate that, para 18, Lordship.
Yes, sir. Yes, sir. I'm on there, on paragraph 8.
We indicate that the respondent could not lay his hand on any rule or regulation applicable to the police force, stating that once an employee has been acquitted by the criminal court as a matter of right, he should be reinstated in service despite all the disciplinary proceedings. Pause for a moment. My learned offense client has relied on the standing order. There is no provision in the standing order, and there cannot be. That once criminal proceedings is acquittal is there, then automatically he will be. Even otherwise, there was no rule of automatic reinstatement on acquittal by a criminal court, even though the charges leveled against the delinquent before the inquiry as well as the criminal court are same. I will show before your lordship the charges in the present case may be of theft, but the evidence, the witnesses are not same.
Not same?
No, I will show before your lordship. The police inspector who conducted the inquiry, he was not placed before the criminal court. That was the ground. In the domestic inquiry, he was never the witness. He cannot be the witness. Then other portions also I will show before your lordship. So on this aspect, the reference made such and such, the judgment is there, lordship. I will not trouble your lordship with this, because I humbly submit before your lordship. I am bothering your lordship on the point. My respectful submissions are on two grounds. One, the
maintainability that I have understood.
Secondly, once the dismissal order has been passed, once it is not being challenged, and he waited till 13 years for the acquittal order to come, when no one adduced evidence or no one could prove, and the standard of proof in the criminal proceedings is to be proved to the hilt. It is not on preponderance of probabilities. Can it be matched? Can it be placed at the same platform? And this is not a case before your lordship that on the ground of pendency of criminal proceedings, well, an client has been dismissed. Separate departmental proceedings have been held. He participated there. He never raised any issue of violation of principles of natural justice. He never said why the report of the
domestic inquiry, who led evidence?
I am coming to that. Kindly take
that. I intend to know.
That certainly. I will take your lordship. Prior to that, lordship, kindly take the trouble to consider page 39 of the writ application.
Page 39.
Time pass over. Page 39, lordship.
Yes, sir.
7 lines from the bottom. The security guard, namely Narugopal Ghosh, Nirmal Kumar Ko, has not been examined by the prosecution side. The IO of this case has not been examined by the prosecution side. So there was no witness. No witness. Then material was also not produced. Now kindly take the trouble to consider page 58 of the affidavit in opposition.
And PW1 is the informant. PW1 is the informant.
I do not know who was there. PW1, I do not know the name. Name has not been written.
PW1 happens to be the complaint of this case.
Yes.
Page number 38.
38.
And what is your affidavit in opposition?
Opposition page 58.
Page 58.
Page 58, Lordship, kindly take the trouble.
Hmm.
PO produced with 2 witnesses from his side. This is the report I am saying before, placing before your Lordship. Sri Nepal Chandra Nayak, Sri Mihir Kumar Bhattacharya. The same witnesses are not there. The PW1 may be the informant. Both the places they are same. But Mr. Mihir Kumar Bhattacharya was never the witness there.
Yes, yes. He also in the criminal.
What number chilo?
Oh, 2. We don't produce.
Mr. Saha, please allow Mr. Dey to submit. It is the finding of the proceeding and finding of the page 55. Okay.
Yes. Now, Lordship, kindly take the trouble to consider affidavit in opposition.
No, they were not the witness to the criminal proceeding.
Mr. Bhattacharya was not.
No, not there.
Not there. Lordship, kindly take the trouble. Page 33 of the
Just a minute.
affidavit in opposition.
It is an inquiry proceeding. No, page 55 is an inquiry proceeding.
Lordship, kindly take the trouble to consider page 33 of the affidavit in
Page 58 and 59. Deposition of Nepal and Mihir. Yes. Any other point, Mr.
Lordship,
Dey?
kindly take the trouble to consider page 33 of the affidavit in opposition.
Page 33.
Of the affidavit in opposition.
Oh, that is the admission.
This is the admission on the day.
Very good.
Now, Lordship, kindly consider when he has admitted and he was put behind the bar, then he ought to have raised the point before the management that I was coerced to do it. I was coerced to do it. He took the plea. My understanding is submitting before your Lordship that before the inquiry officer he adduced evidence and management did not cross-examine. Will that negate? May I put a question to myself? When the admission is standing, is staring at the face of my learned defense client. And Lordship, kindly consider the charge sheet was issued that your Lordship has taken note of. He did not submit any reply. Then inquiry proceedings held, Lordship, page 39, affidavit in opposition, page 39 to
Mr. De, I believe I have understood your case.
Lord.
Thank you for your submission. Let me dictate my judgment. Take down.
My lord, under compelling circumstances, may I be mentioned one thing, my lord, for upgradation, 65 is my list. As your lordship is not setting the
Sir, upgradation is not permissible.
My lord, once previously I have mentioned my client is in deathbed, my lord, and he is just leaving to get to get the justice from your lordship. He actually has been exonerated from the CBI charges and all, but is the total amount which has been kept in the bank in the UBI, now it is PNB, it is now freezed. We are here for defreezing. Only one petition, my lord, only one hearing will be disposed of. Nothing else is there, my lord.
Come tomorrow, mention after notice. I shall consider that.
My lord, notice has already been given because in the notice has already been given to the other side. Just for upgradation under the to be mentioned, my lord, tomorrow, as your lordship is not very well sitting, I know your lordship is occupied with so much work.
What can be done, sir?
I can help my lord. 65, my lord, under to
You serve notice that I shall consider. Serve notice and then mention. I cannot give you. Acha, we judge.
Is actually in no, this is running. This is running.
Sir, come tomorrow. Come tomorrow morning. I shall consider.
Okay.
যে পিটিশন গুলো জাজমেন্ট গুলো যেন মিক্স আপ না হয়, যেগুলো রেসপন্ডেন্ট করেছে ওগুলো একটা ফাইলে রাখবেন, আর যেগুলো পিটিশন করেছে নাহলে কিন্তু মিক্সিং করলে মুশকিল হয়ে যাবে।